All right, everyone, welcome back to AP US History. So today we're going to be talking about two different topics. So the ratification debate, obviously, since that's on the screen, where we have the Federalists versus the Anti-Federalists, and we're also going to be talking about the Bill of Rights, the first 10 amendments to the Constitution. All right, so let's go ahead and get started. So the US Constitution. September 17, 1787, the draft was approved, and then it is sent for ratification, which is going to basically take a year of debate for it to be ratified, which means it is to be passed by a majority of states. We need 9 out of the 13 states to approve it for it to go into full effect for the country, which would include all 13 states. All right, so a couple of major leaders not involved with the Constitutional Convention and getting it involved with ratification and all are these guys here. So John Jay, a prominent lawyer, Thomas Jefferson, John Adams, and Thomas Paine, they are away on diplomatic business. Like Jefferson, he was like the ambassador to France during this time. Samuel Adams and John Hancock, they were not chosen to be a part of the conference. And Patrick Henry, he was just, no, I'm not doing it. So we have other people who are very prominent founding fathers who were involved, such as these guys. And because of the controversy over the Constitution, we're going to have our two sides that come into effect here: the Federalists who want the Constitution, and the Anti-Federalists who do not want the Constitution. So our Federalists, our main people here are George Washington, Benjamin Franklin, James Madison, and Alexander Hamilton. And the Federalist argument is they want a strong central government in order to maintain order and preserve the country. They are going to be pushing the weaknesses of the articles and showing that there's really no solutions to fixing this. And the advantages to the Constitution is we have strong leadership, it's more well organized, and we have what is called the Federalist Papers. We'll be talking about that shortly. The disadvantages: it's new, it's untested, and there's no Bill of Rights. All right, now the Anti-Federalists, we have people like Virginian Patrick Henry, we have John Hancock from Massachusetts, and George Clinton from New York. If I remember correctly, he is an ancestor of former President Bill Clinton, but I'm not positive. All right, the arguments: strong central government would destroy the work that the revolution did because we had just gotten rid of a strong central government. They are pushing for limited democracy and, well, they are pushing for limited central government because they believe that a strong central government would limit democracy and would restrict the rights of the individual states. So their strategy was offering that the Constitution had no protection of individual rights, so the lack of a Bill of Rights, and that it would basically show that this central government would have more power over the states than the British Empire ever did over the 13 colonies. So they're going to appeal to popular distrust of a strong government. But the disadvantages of their side: poorly organized, and they were very slow to respond to the arguments of the Federalists. All right, so where are these groups located? The Federalists, they're along the East Coast, and especially in the larger cities. On the map, they are the purplish, darker color. And the Anti-Federalists are more western, and they are the farmers. So we have a lot in the South and into the more western territories like Western Virginia, North Carolina, South Carolina, into the Kentucky area, upstate New York, where there's a lot of farmland. So, yeah, the heart of the debate, of course, is power. Who should hold more power? A central government, a strong central government, or the states? That is the key thing that is up for grab here. Now, ratification early on, Delaware, New Jersey, and Pennsylvania are going to get on board with ratifying the Constitution. We're going to have some strong campaigning in New York and in Virginia. That's especially where the Federalist Papers come in. These are a series of articles and essays that are basically pushing for the people to want the Constitution to come into effect. They are written by James Madison, especially Alexander Hamilton. He wrote the majority of them, as well as John Jay. And they're basically explaining the virtues of the Constitution, such as Federalist Paper number 10, arguing a large republic would actually protect minority rights better than a small republic. So big government, such as a federal government, national government, would have more of an ability to protect people's individual rights than just a strong state. Now, the Federalists are also going to promise to add a Bill of Rights. And that takes away the Anti-Federalists' most powerful argument against them, because it's like, hey, this Constitution doesn't protect our individual rights. Oh, yes, it will, if we put in a Bill of Rights. All right, so Federalist Papers, getting into it just a little bit more. Basically, these articles their goal is to convince people that the Constitution is the answer, that it is a great way for the country to be governed, and that it shows that it can evolve with the times so that we don't have a reason for revolution and these crazy political debates in the future. And that by allowing things like amendments, it can evolve to the times so that it is a fluid government. It flows throughout the ages. And like this last bullet, it is probably the greatest contribution of America to political theory around the world. It's going to serve as an example to future governments that come into existence, such as, after the French Revolution, the South American revolutions, and, Vietnam in the, 60s and 70s is going to even take some examples from America. There's going to be like Japan after World War II, their new government that they have now is modeled after ours. It's going to be an example to the world. It's called the American experiment because this is a government system that had never really happened before, and it's been in existence for over 200 years now. I'd say it's, going pretty good overall. All right. So the ratification, this chart is basically showing the votes for and against the Constitution coming into existence. And as you can see by going down this, in every single state, more people voted for the Constitution to become law than voted against it. Significantly, once you add up all the numbers all up. All right, moving on. So the legacy of the Constitution, basically, it's going to safeguard against mob rule. And what that means is it's not direct democracy, which is, say, for a presidential election. That's why we don't have the popular vote, because the masses, generally speaking, are not always the most educated on political ideas and theories. So that's why we have stuff like the Electoral College in place, where it is the republic system. We have representatives involved with the government decisions for us, because if it was direct democracy, nothing would get accomplished, because anyone could speak, anyone can make an argument, everyone's got to listen. If we have people elected into position to represent us as a whole, it just moves more smoothly. And because they're supposed to, the representatives, such as like the Senate and the House of Representatives, they are supposed to do their decisions on voting for things. Of course, they can take their own thoughts into consideration, but they are supposed to really speak for the people in their constituents, the people they represent in their voting district. All right. So some other legacy pieces: restoring the economic and political stability of the colonial years. So basically getting the money back on track, which it did. Set the drifting ship of state on a more promising course, basically getting our affairs in order and basically keeping a democratic form of government and redefining popular sovereignty, basically having decisions based on the will of the people, the majority of the people. Now, the genius of the Constitution, basically, it embeds the doctrine of self-rule in a self-limiting system of checks and balances, and it reconciles the political conflict of, liberty and law and order. So what that basically is saying that the Constitution, it keeps itself in check from anything becoming too abusive and keeping things as legal and straightforward as it can. All right, so that is ratification. Let's talk about the Bill of Rights. This is going to take a little bit because there are 10 of them, and we're going to just basically give the breakdown of what each of them means. So, getting into it, what does the Bill of Rights mean? The Supreme Court gives us the meanings of what they are. So, the Supreme Court, yes, this is an older picture, back in 2008. So, the Supreme Court balances the rights of the individual with the needs of society. So, what is fair to everyone and the individual? So, the First Amendment, we get 5 individual rights from the First Amendment: freedom of speech, religion, freedom of the press, of assembly, and the freedom to petition the government. All right, free speech. Basically, you can say whatever you want, but there are limits. So threatening to blow up airplanes, schools, or the president, you can't say that because, that's more terrorist activity. Sexual harassment, of course, is not okay. And to incite chaos. So basically, if you give a fiery speech and then a riot starts because you riled up the crowd too much, you can get in trouble. Also, using extremely crude language in public, like if you start cursing and using sexual language in front of children, that's a big no-no. All right, being disrespectful and vulgar language in schools. So if you go crazy starting to cuss someone out, yeah, you're getting in trouble. And of course, hate crimes. That's a big no-no as well. All right, individuals, you can say whatever political beliefs you have, whether you're left, right, conservative, liberal, socialist, communist, you can speak your mind. You have the right to protest as long as it doesn't get out of control. If it moves from a protest to a riot where violence begins to happen, then it's no longer free speech. You're now committing a crime because violence is happening. That is the difference. All right? You can say things about someone that are true. If you are speaking false things about someone, that is slander, and that is actually a crime. All right? You can burn the flag in protest, but that is kind of a slippery slope. That one's kind of more in the gray area. Some people view it as a crime. Other people view it as a form of protest, a nonviolent form of protest. That one's up for debate. All right, you can say racist and hate slogans, sort of, but if it leads to violence, then it's a crime. You can say things, but if it leads to action, that's a problem. All right, free speech means you can say something and somebody can say something you disagree with. And that's it. You can't insult somebody just because they disagree with you. You can't try to have someone arrested because they disagree with you. Words don't actually hurt people unless it turns people violent. Once violence breaks out from words, then you have a crime. But you can say whatever you want all day long as it doesn't lead to violence. All right, freedom of religion, that one's very straightforward. It gives us two things, the Establishment Clause and the Free Exercise Clause. So the Establishment of and Free Exercise Clauses often conflict with one another. So in schools, religion issue is very prevalent. Like, can you make kids pray? Can you not make them pray? Can you limit those sorts of things? So a student can raise their hand and say, can we say an opening prayer before this test? If the teacher says yes, it looks like establishing religion as a rule in the school. If the teacher says no, you're denying the students free exercise of their religious beliefs. So yeah, it's more like why there's a moment of silence. Someone can use it just to, whoever wants to pray can pray during that time. Whoever wants to meditate can meditate during that time. Or you can just sit there and just twiddle your thumbs until the moment of silence is over if you don't want to practice anything religious or and examining yourself. All right. Now, the Establishment Clause basically states the government cannot promote religion either. That's the separation of church and state. That is a principle of the Constitution. No state-mandated religion, because that has led to a lot of problems in the past. So, but what the government can and cannot do is this. The government can teach about religions in school. That's why in history class, you learn about various religions. You learn about Hinduism, you learn about Judaism, you learn about Islam, you learn about Buddhism, you learn about all these different things. Zoroastrianism, when you're talking about the ancient Persians. All right, you allow voluntary prayer in instances such as a moment of silence at the beginning of the day. And you can transport students to a religious school. So like if there's a Christian school, for instance. All right. Bible verses can be read in school as long as it's intended for historical or cultural or literature study. If you're not teaching religious doctrine, it's okay. But if you give it a twist to where you're preaching religion and trying to basically push religion onto students, then it's a problem. So the government cannot set a state religion, cannot order people to pray. You cannot teach religious doctrine in school. You can teach about various religions, but you cannot push people into trying to believe that religion. All right? A government cannot pay religious teachers. They are not employees of the school, which is why religious schools like a Catholic school or a Protestant school, that is why they are private schools. They're privately funded. They are not government sponsored through the state or anything. All right? And the government cannot teach creationism. God created the earth in 6 days and rested on the seventh. That is not something that the government can push to be taught. Now, if you're just talking about the history of Christianity and be like, this is what Christians believe, this is what Jews believe, this is what Islam believes, then it's okay. But if you're trying to teach it as doctrine, as a true fact, that's kind of a gray area that you don't really want to get into. All right, free exercise. People can choose any religion they want, whether it's Christianity, Satanism, whatever. All right, people can lead a prayer in most instances. Like during a moment of silence, if there's a little group that wants to go into a corner and pray in a circle, they can do that if they wish. They can ask questions about religion. But you cannot break the law and claim that it is a religious belief. No, you can't do that. You can't be like, you can't rob a bank and be like, oh, it's my religion to rob banks because I want money and I worship money. No, you can't do that. And you cannot raise children without an education. That's something else that, you can't do. Kids have to go to school. And you cannot deprive children of basic needs. Okay. Freedom of the press, I think that one's pretty easy. Basically, the press can print any political position. They can make fun of people, especially politicians, and they can expose wrongs by the government. And they can say things you might not agree with. But they cannot commit libel, which is intentionally injuring a person's reputation through false facts. That is a crime. Right? They cannot disclose classified government secrets. If the government has something classified, they are not supposed to release it. And they cannot detail how to make certain types of weapons, like dynamite or napalm. They can't give the formula for how to make those things, because then you're going to have idiots in their garages making bombs and then blowing themselves up. Right? Freedom of assembly. People can protest. They can hold parades as long as there's a permit. Same thing with protests. You need permits for that as well in a lot of cases. You can parade chanting hate slogans. You can gather in public. But you cannot protest by throwing rocks and breaking windows. That is a riot. That is bad because it's violent and it causes property damage. That is criminal offense. And you cannot hang out on private land without the owner's permission. So if people are going to protest and they're camping out along a roadside that is actually owned by a farmer, the farmer has every right to chase people off their land with a tractor, or to call the police and have them escorted off of the property because it's private property. All right, petition the government. So you can sue the government for wrongs that they commit. You cannot be punished for exposing the wrongs of the government, and the courts decide what the wrongs are. All right, Second Amendment. Yes, this is going to take us a little bit. I do apologize. The right to bear arms is the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to bear arms shall not be infringed. What this is saying is, well, let's look at this question. Well, these two questions. How much can the government do to keep guns from criminals and youth? And in order to keep guns away from criminals, does that limit the right of law-abiding citizens? Okay, so thousands of people every year die because of guns, and thousands of crimes are also prevented because of guns. That is the debate. How much access should people be allowed to have? So, yeah, that's a very controversial topic right there. It's kind of one that, we have the right to own firearms. We do. But the idea is, does the government have the right to limit what we have access to as civilians? And like, are we only allowed to have guns with a certain capacity? So like, are we allowed to have guns with 10 rounds maximum, 20 rounds maximum, 30 rounds maximum, 100 rounds maximum? And are we only allowed to have certain types of calibers and gauges and things like that? Or of a certain size? Like, you can't have a shotgun with a barrel less than 16 inches, or a rifle with a barrel less than 20 inches, or a pistol that is no smaller than the palm of your hand. It is one of those things that is always going to be up for debate. Okay, so moving on. Third Amendment. The government cannot force you to shelter soldiers in your home without your consent in a time of war or peace. So yeah, that one's pretty straightforward. And now Amendments 4 through 8 preserve the rights of the accused, such as if you get arrested for a crime. All right, Fourth Amendment. So this one talks about does the government need what does the government need to search your home? They need probable cause, meaning there's a legitimate reason for them to do so. And they have to have a warrant given to them by a judge. All right. So there is a difference between this. Okay. So probable cause is more if in place if there is not a warrant. So say you get pulled over by a cop if you're speeding and you have, let's say you got a bag of weed sitting on the back seat and the cop can see it very clearly sitting on the back seat just by looking through the back window. That's probable cause to search your vehicle. They can ask you to get out of the car and they can search the vehicle, be like, hey, I see that right there. I'm going to search the rest of your car now to see what else you got. That's probable cause. If a cop comes to the front door and knocks and they hear a scream from inside the house, they have the right to kick the door open and look and find out what's going on. If none of that is the case, they need a warrant to search a vehicle if there is nothing visibly accessible in the car just by looking through the windows. Or if they don't hear or see anything at a house and they want to search it, they need a warrant given by a judge. All right, Fifth Amendment. You cannot be tried for the same crime twice. This is called double jeopardy. So you do not have to testify against yourself. So if someone's trying to get you to testify against yourself, you can go, I plead the fifth, meaning, they can't do that. So you also must have due process of law before you're convicted. You have to go through the channels of law, meaning you need to go before a judge, decisions need to be made. You can't just go from being arrested to being in prison for 10 years. That doesn't happen. The government cannot take your land unless it pays for it either. They cannot just seize land. They have to compensate you. Sixth Amendment, you have the right to a speedy trial and the right to a lawyer. All right. So you can't just sit in jail for 5 years waiting for your case to eventually go before a judge and a jury. It has to happen in no more than 2 years. All right. And if you cannot provide a lawyer for yourself, the government has to give you one. So think of the Miranda rights for any of you who watch cop shows. So placing you under arrest for blah, blah, blah. You have the right to an attorney. If you cannot afford one, one will be appointed for you. All right, Seventh Amendment, civil trial by jury. All right, basically, if you're being sued, you have the right to a trial by jury. Eighth Amendment, bail and punishment. No excessive bails. You don't if I am getting arrested for breaking into a car, I can't have a bail posted for $100,000. That's excessive. And also, if I get arrested for breaking into a car, I can't, get the lethal injection for it. I can't be executed for that. That's excessive punishment, cruel and unusual. All right, Ninth Amendment, rights reserved to the states. Basically, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Very confusing wording there. So what that means is this allows states to grant more rights than given under the Constitution. Basically, whatever the Constitution doesn't have jurisdiction over, the states have the right to govern over. Right? Such as gay marriage. That's why some states it's legal and other states it's not. That is not a federal decision. The drinking age. The driving age. So, like in Virginia, you get your driver's permit at 15. You can have your license at 16. In other states, like I'm originally from New Jersey, you couldn't get your permit until you're 16. You can get your license until you're 17. So that's one example there. All right. Abortion limitations. So some states are more open with abortions than others. Think California versus Nebraska. All right, 10th Amendment. Rights reserved to the people. So the power is not delegated to the United States by the Constitution nor prohibited by it to the states, are reserved to the states respectively or to the people. So basically what that means is if the federal and state governments do not prohibit something, then the people are allowed to do it. So yeah, if there's no law against it, you can do it, whether it's state or federal level. All right, that is where we are ending today. I hope you guys enjoyed it. So be sure to come back next time, and we are going to be talking about basically the rise of political parties in U.S. politics. All right, talk to you next time.